Brother Dominic.
Good evening, everyone. Thank you, Reverend Chantal.
You're welcome.
Our presenter this evening is well known to us in our Moravian community. He is an ardent Moravian and a hard worker in the Church of Jesus Christ. He was admitted to practice in 1991 and has been the managing partner of the firm Nunes Schofield, Dillon and Co. since 2010. He's a member of the Jamaica Bar Association and chairs the Finance and Accounting Committee on the General Legal Council. He's also the course director for the course Law Office Management, Accounting and Technology at the Norman Manley Law School. He hails from Betharbara Moravian Church and is now a member at Covenant Moravian Church in St. Andrew, where he serves as a member of the Board of Stewards. Provincially, he has been a lay member on the Provincial Elders Conference, the administration for the Moravian Church, since 2003, and is currently serving on the PEC as its treasurer. He's also the chair for the Bethlehem Moravian College Board of Management. Brothers and sisters, by now you must all know who I'm talking about. And so I hand over to our presenter for this evening, Brother Lowell George Morgan.
Okay, should I go ahead and start sharing screen, Brother Lowell, before you speak?
Yes.
Okay.
Go ahead.
All right. I'm coming.
Is everything in order? Are you?
Yes,
clear?
I'm ready. I'm ready.
And
Oh, what's
you see
happening
me
here
clearly?
now? Oh, what's going on here now? Oh boy. All right, something is hiding the share screen. Oh, good. Good. Oops.
All right.
I'm coming.
So you don't want to see me?
No, I'm soon come to that one. I soon fix that. I'm trying to make this a slideshow first. All right, get this back up here. And, oh Lord, what did I do wrong? All right, something, all right. I thought I had set up everything so that you would be the only person. Oh, okay. Yes, you're seeing you. You might. Are you guys seeing Brother Lowell?
Yes, we are.
Yes, we are.
Okay, good.
No.
Go ahead, Brother Lowell.
I have not seen Brother.
I'm not seeing him at all.
I'm not seeing him.
I'm not
Seeing the
seeing.
presentation?
Yes.
Okay.
Yes, we are seeing
You might have to
presentation,
set
Sister
your
Lee.
thing to see. Set it on speaker view, if you can. We're not using webinar.
I'm seeing him now.
Yes.
Okay. When we
seeing
can
him
afford
now.
a webinar, we'll have a split screen, a nice split screen.
I'm seeing him now.
Okay.
Good evening, my brothers and sisters, friends all. Today is August 1. It's a bittersweet day for me because today's my mom's birthday. You know, my mom passed away on June the 12th. And today would have been her birthday, her 83rd birthday. Nobody warned me about the difficulties. Some people try to warn me about the difficulties of this process. And so today has been a very, very sad one for me. But I had to muster up all the strength and all the courage to ensure that I do this task that I committed to do some months ago. You see, my friends, my mom was my greatest cheerleader. And I'm absolutely sure that if she were alive, she would have logged on and cheered me on today. So it's tough, but we have to go. I want to start by telling you a bit about stewardship, because that's the word that came to mind this morning. Let us make man in our own image according to our likeness, and let them rule over the fish of the sea and over the birds of the sky and over the cattle and over all the earth and over every creeping thing that creeps on earth. This subject of stewardship causes confusion and consternation among Christians. The issue of money is really only a small part of stewardship. When rightly understood, stewardship can bring Christians true joy and transform the way we live. The word stewardship refers to an administration or an economy, a way of operating. We can also call it management. The proper definition of stewardship is given by its author, God himself. The Bible begins with God creating, talking, and doing. He made the earth and mankind, and therefore he is the owner of all things. God created and then gave his responsibility to humanity to manage his creation. So my brothers and sisters, we don't own anything on earth. We don't own the land. It is God's property. The Bible is very clear about it. In Exodus 19 and verse 5, God says, all the earth is mine. And in Psalm 89 and verse 11, the psalmist says to God, the world and all it contains, you have founded them. So we own nothing. And when we leave the earth, we won't take anything with us, because God is absolute owner, because he's absolute sovereign and king of the universe. Yet God has entrusted each of us with our spheres of influence and stewardship on earth. He's watching to see how we will manage what he has given to us. So I encourage us all, be a good steward of our time, our treasures, our talents, because our Father in heaven rewards what you do. I want to thank the Department of Education, Mission and Youth for the invitation to present this lecture. They started out by asking me to speak about land freedom, common understanding, land rights, ownerships, and somewhere in between, the director said to me, you needed to speak about estate planning consideration. For me, it is a teaching moment, so it wouldn't be one of those standard lectures. It is a teaching moment. And for those of you who are not so savvy and high-tech and can do what you can on your phones or on your laptops or on your tablets, I ask if you could get a sheet of paper and a pen, because as we go through this lecture, I will seek to answer some questions that would have come to me over the last number of years in relation to land ownership, etc. And I will look at some issues regarding estate planning. So by way of introduction, I will say celebrating emancipation in Jamaica naturally makes one consider the importance of land ownership for the recently liberated Africans in 1836, just 4 years after slavery was formally abolished and the apprenticeships period came to an end. Fast forward almost 190 years, while many things have evolved, some aspects have stayed the same. Land ownership, my friends, continues to be a crucial aspect of wealth and power in Jamaica. And many families hold onto land that has been passed down for generations. However, the issue of land rights, ownership disputes, estate planning consideration still plague many of us. So as the country celebrates its freedom from slavery, I believe it is essential to consider how to ensure that all, and if not all, most Jamaicans have access to land ownership and opportunities for economic advancement. So in this paper, I will highlight the historical trajectory of land rights. And I will look at some of the more common applications that you will see. Applications such as an application for a registered title, especially for those outside of the corporate area who live on land for a number of years and do not have a registered title. So I will address that. I will address the issue of lost title application. That is, you own a piece of land, you have a title or house or whatever, and you lost the title or the title is destroyed. And so I will look at that. How do you get a new title? I will look at something we call transmission application. So you pass on, you name executors, and what are the roles of those executors vis-a-vis the property that you own. I will look at caveats. I will explain what it is and how you go about lodging caveats and the reasons that you can lodge caveats for. I will look at the vexed topic of adverse possession and squatting and how, after living on land for a number of years, you can acquire a title. I will go through step by step as to how to do it. And then I will address some estate planning considerations. In particular, I will look at the question of wills, the importance of wills, why you make a will, etc. And remind you as always that you should leave something for your church, the Moravian Church, when you make your will. So that's in a nutshell what I wish to speak about in the next 45 minutes or so. I ask you to bear with me. I did a paper and I asked, it has been sent to Demi. I asked Demi if they could distribute it to the persons who want it, and those of you who have asked by email, etc. I'll definitely ensure that I send you a copy. So firstly, the overall overview of land rights and ownership in Jamaica. The fundamentals of property law revolve around land. The ground we walk on always has anything in it and on it are considered part of the land. It is an asset with significant potential and substantial value. And so the location, the size, the appearance, the accessibility are all play a significant role in determining its value.
Brother Lowell,
yes.
I'm going to ask you to let me know if I'm on the correct slide, if I need to go forward, etc. Please.
Okay, let me get. Slide 3. Real estate,
I need to go back there saying, sorry.
I'm saying you could go to slide 3. Real estate
Oops.
includes permanent features of the land itself, minerals, water, and structures. The term land rights for me refers to the rights that one has over land. And private land is defined as land that does not have rights granted by the government. Land ownership is proof of a person's ownership of a parcel of land. So for example, land can also include the natural resources, such as trees, crops, and wildlife. I recall, the bauxite companies compulsory acquire land from time to time from persons living on the property. The government, as you know, can compulsory acquire land if it wishes to do so. And one of the things I know, for example, that the bauxite company pays for is the resources on the land. And I remembered even so far as counting the number of orange trees and tangerine trees, etc., that you have on the land, and the number of crops from the yam hills, etc., etc. Those are parts of your land. And on compulsory acquisition, I know that you are paid for those things. Additionally, land rights can extend to air rights, which refers to the right to use and control the space above property. So understanding what is included in land ownership is crucial for individuals looking to invest in real estate or to develop properties. Understanding the intricacies of land rights is also crucial for anyone looking to invest in real estate and for long-term plans for the future. I want to look first now at the historical context of land ownership in Jamaica. Land ownership in Jamaica has a rich historical context that dates back to colonial times. The system of land interest in Jamaica is complex, I would say, and various rights and responsibilities attached to different types of ownership. So, as freedom approached in the 1830s, the Baptist minister and abolitionist, the Reverend James Philippo, along with missionaries William Knibb and Thomas Burchell, fought for the liberation of the enslaved population and the establishment of free villages. In anticipation of full freedom, the Baptist ministries acquired land for settlement where the newly emancipated people could live. They could build their homes, they could farm, they could start businesses without fear of being removed from former owners. They achieved this milestone with the acquisition of the first free village in Sligoville in 1835. I mentioned here briefly that the first free village in Manchester was at Maidstone. And I will say more about that later on, but I can tell you that at the museum in Maidstone, there is a lot of history about the Moravian involvement in free villages. And I'm sure you can get this information from some of our historians. Brother Garth Smith is one, Sister Lucinda Peart is another. Where's Maidstone? Maidstone, especially for those in town, in Kingston, is a rural community situated on the northern section of the Don Figueroa Mountains. It's approximately 24 kilometers west of Mandeville. The district surrounds Maidstone includes a place named Mons, Glenhead, Adam Valley, Johns Hall, etc. Bath to the south, Huntley as well. the area is hilly and stony and at times windy and dry. It was amongst the first land settlement developed for former slaves in Jamaica and the first community of its kind in northwestern Manchester. The village takes the name Medstone from the slavery property, and the Moravians bought and subdivided lands, making communities in which ex-slaves bought and owned lands. But let me tell you briefly about the work of the Moravians in the area. When the Moravian missionaries came to Jamaica in 1754, the slave plantations in Medstone were already in full swing, producing coffee. They were producing pimento, cotton, and tobacco. Their missionary work brought them to the actual plantations where they took the gospel to the slaves. These included Medstone, which had some 65 slaves, with John Cohen as its proprietor. He also had control of the Bath property with 13 slaves, while his neighbor John Coley had the John Hall's property with 170 slaves. Hyman and Judy Cohen and the Mons property had 170 slaves, and other properties had various number of slaves. Huntley, for example, had 124 slaves. The missionaries expanded their work into the field of education and built what was called a chapel school at Adams Valley in 1838. The building was used during the war to accommodate school and used on Sundays as church. In 1840, just 2 years after full emancipation, the Moravian missionaries bought the Medstone property consisting of 341 acres. They subdivided it into some 98 plots, ranging from 1 to 15 acres in size. At that time, 75 persons were allotted lots. Lots of 1 to 2 acres cost approximately £6, while 10 acres and over cost 60 to 75 pounds. The missionaries worked out a payment plan to enable the ex-slaves to complete the payment for their lands by 1850. They also organized the ex-slaves to help each other to clear their land, build what we call wattle and daub houses, and prepare their fields to grow their crops. They also provide technical guidance and support in physical layout of the village. So in the immediate aftermath of emancipation, the church served as more than just a religious institution for the former slaves. It emerged as a pivotal source of education, a hub for community leadership, and a platform for empowerment. Additionally, the church offered training in domestic management skills and facilitated conflict resolution. Even though the majority of plantation lands at the parish level were occupied by workers who lacked sufficient living quarters, only 1% of the lands were granted to them. They were given full property rights, but were required to pay for every transaction involving land. In 1836, the promise of freedom in Jamaica led to distress among the indigenous people who had no place to live. The British government presented legislation to Parliament, but the views of the affected people were not recorded. The Privy Council prepared orders for emancipation, including compensation for lands taken and a 2% fund to encourage free people to emigrate. However, the Emancipation Act of 1833 did not grant enslaved Africans the right to own property. So from 1836 to 1865, efforts to attain land ownership increased, and legislation was passed to evict peasant class from unoccupied lands. Large-scale ownership introduced taxes and toll gates to trap movement and to obstruct the free people's access to markets and towns. And when the aggrieved peasants petitioned Queen Victoria for reprieve from taxes and tolls and for titling for the land to secure ownership rights, their concerns were not adequately addressed. And this, my friends, led to riots like the Morant Bay Rebellion of 1865, led by the Baptist preacher Paul Bogle, who is one of our national heroes. Following, though, the Morant Bay Rebellion, the government dissolved the assembly, resulting in Jamaica becoming a crown council between 1865 and 1889. This brought significant changes to land ownership, transfer, and lease arrangement, which still exists today. And numerous laws were enacted to address legal ownership and transfer of crown lands. It is important to note that many of the former enslaved individuals who were now part of the peasant class were landless. Although there were legislative changes to address land ownership issues, there were three significant pieces of legislation that deserve mention. The first one is the Alien Law Amendment Act of 1871. The second one is the Married Woman Property Rights Law of 1886. And the third one, a very important piece of legislation, is the Registration of Titles Act of 1889. And this act established a legislative framework and a registry system to simplify dealings with land and to ensure certainty in land titles. Furthermore, mid to late 19th century legislative changes, including enactment of the same registration of charters of titles act, which adopted what we know as the Torrens system of registration, has a lasting impact on land ownership and transfer in Jamaica. That's the history, my brothers and sisters. But I must mention and speak specifically of what we call the Torrens system. It's a system outside of developed in, we copied from Australia, Torrens system. And it is a centralized system of public record, which regulates the registration of land in Jamaica or in the jurisdiction. One of the critical features of the Register Book of Titles is what we call the issuance of a certificate of title for the registered parcel of land. So I hear people say them have them title. You have a certificate of title for the registered parcel of land. The original certificate, though, is kept by the registrar of title. And the registered proprietor, that is you and I who own property, we are issued what you call a duplicate certificate of title. And my brothers and sisters, we're talking about registered land now. So you have what you call, what you say is your title. If the bank have it because you borrow money or whatever, it's a duplicate certificate of title. The original is in Kingston in a vault at the Registrar of Title. That certificate that you have also bear a title reference and a number identified as the volume and folio number, which is specific to the parcel of land contained in the title. So the title have what we call volume and folio number, and it is specific. The proprietor, that's you, would be able to use your title, your duplicate, to track the transaction, owners, and encumbrances relating to your land. As a duplicate mirrors what the registrar has in Kingston. Further, you need not look further than the duplicate to ascertain information regarding your property. The certificate is divided into 3 sections. It describes your land. It details the registered proprietors. It says that you own it or who own it. And finally, it lists any what we call encumbrances affecting the land. The Torrens system, the same system that I said we developed from Australia, has also made transaction easier and more efficient, with the official title serving as conclusive proof of ownership. So when you have this title, it is conclusive that you own this piece of land. I will also tell you that the same system, Torrens system, has played a role in promoting economic development and investment in Jamaica. With clear and secure property rights, individuals and business are more willing to invest in land and real estate, knowing their ownership of the land is legally protected. And this has led to increased development, construction, infrastructure projects, etc., across Jamaica, driving economic growth and prosperity. As a result of the Torrens system with a specific registration of land, Jamaica has seen a rise in property values, as well as a boost in the overall real estate market, making it a more attractive destination for local and foreign investors. So we have certainty when it comes to ownership of land, and we have a clear system of ownership. For the lawyers, I mentioned the specific, I will look at land registration process in Jamaica, and I looked at Section 2 of the Registration of Titles Act, which speaks about that, but I will move down and say that the Act prescribes a system of title that protects the owner. I said that already. And we say when you have the title, it is, we speak in law about the indefeasibility of the title. And title can only be issued through the process, as I say, in the Registration of Titles Act. The land registration process in Jamaica is managed by the National Land Agency. And the National Land Agency is an executive agency of the Ministry of Economic Growth and Job Creation, dealing with core land information functions of government, and it includes land titling, surveys and mapping, land valuation, estate management, etc. So we have Registration of Titles Act. We speak about the Torrens system, and I'm saying we have a clear registration system in Jamaica. When you own a piece of land, your title is what we say is indefeasible. You own this piece of land or this piece of property, it is yours. The Registrar of Title in Kingston has the original, you have the duplicate. It is a mirror of the duplicate. It tells you the volume and folio number. It tells you if there are any encumbrances. It tells you what size land you have. And I'm also saying that in Jamaica, land registration process is managed by the National Land Agency, which is an executive agency of the Ministry of Economic Growth and Job Creation. So my friends, my brothers and sisters, we have land ownership. We have the history of it. We speak about the involvement of the Baptist minister, James Philippo. We spoke about the free villages, first one in Sligoville, 1835. We looked at the first free village in Manchester, dear to the Moravians, Medstone, 1840. I mentioned to you the role of the Moravians in terms of land. And I mentioned also that we have a rich history and that we have some historians who can tell us about land. I mentioned 3 important legislation: the Alien Law Amendment Act, the Married Women's Property Act, the Registration of Titles Act. And once you look at the Registration of Titles Act, then you will have to look at the Torrens system, which is a registration system we mirrored from Australia. And that's where we are in a nutshell before we get on to other things. I want now to look at the types of land ownership in Jamaica. Acquiring property in Jamaica requires careful planning and consideration. And one such consideration is a type of ownership one would embark on before you purchase. In other words, my brothers and sisters, I'm suggesting that you must have careful planning and you must consider the type of ownership that you wish when you're trying to acquire ownership of land in Jamaica. In other words, when you're trying to obtain one of this, what we call duplicate certificate of title that is indefeasible, to say, yes, I own this piece of land or this piece of property on which I will build my house or on which the house is. That's what I'm talking about. Before you acquire this, you need to consider a number of things. Essentially, there are 3 types of ownership. The first one, and if you have a paper, you jot this down. Sole ownership. What's sole ownership? This occurs when a single person owns a complete interest in a property. So when a single person owns the land, he owns the complete interest in the property. And that person is able to undertake all acts of ownership. Absolutely. For example, using the land for security for loan. So if you own the land, you own the property. When I talk about land, I'm talking about the things on it, like the house on it, etc. If you're a sole owner and you need to borrow money, you don't have to ask anybody else. You can use your land for security for a loan. If you're a sole owner, you can transfer your property to another person and you don't have to ask anybody anything about it. If you are a sole owner, you can devise, what I say, a better word, you can give it to anybody you want under your will. So the first type of ownership of property in Jamaica is sole ownership. Then you have joint ownership, my brothers and sisters, joint ownership. And under joint ownership, you have 2 types. You have what we call joint tenancy, and you have what we call tenancy in common. Joint tenancy, tenancy in common. Joint tenancy first. Joint tenancy refers to a situation in which you have more than one owners now. It's not one. But each of the owners is entitled to the entire property. So if 4 persons own the property by joint tenancy, 3 persons or 2 persons, each of them is entitled to the entire property. And when one owner dies, the surviving owner receives the person who died share of the property. So my friends, brothers and sisters, if 3 people own the property, joint tenants, and one die, the other 2 persons become the owner for the property. If 2 persons own the property as joint tenant and one dies, the other person becomes the sole owner of the property. As a result, the first joint tenant to die is unable to dispose of his property by his will. So if 3 people own the property, you can will to say, my interest in this should go to X, Y, and Z. However, and my probate persons in the office will be proud of me, they say, It is still recommended when you are preparing a will, if the property is jointly held, that the testator, the person who makes a will, is in fact the last surviving joint tenant at the time of death. So the recommendation that when preparing a will, even if the property is held jointly, you should still account for it in your will in the event the person who is making the will is the last surviving joint tenant at the time of death. So you have joint tenancy, my brothers and sisters, 2 or 3 people, all of them have entitlement to the property. Then you have tenancy in common. So remember we started sole owner, then I said joint ownership. And under joint ownership, you can be a joint tenant or tenant in common. The tenant in common refers to a situation in which each owner, each person, so if there's 2 persons, is entitled to a distinct but undivided share of the property. You have 3 people, 3 of them entitled to the property, distinct, undivided share. So if the property is owned as tenant in common, when one owner dies, his or her share passes to his estate and will be distributed according to his will or according to the law if the person didn't leave a will. So in tenants in common, each owner can dispose of his share by his will. You can't do that under tenancy in common, in joint tenancy. But under tenant in common, you should provide for your interest in the property by your will. So under tenancy in common, the interest of a tenant in common does not automatically pass to the other owners. So let me be clear. Joint tenancy, what we say, the principle of survivorship applies in joint tenancy. One joint tenant dies, the property goes to the remaining joint tenants. In tenancy in common, if one person dies, that person's interest goes to whoever that person says it should go to in accordance with their will, and the person didn't leave a will, it goes to their estate and is distributed in accordance with the rules of intestacy. I've been asked, and I know some of you will be there asking yourself or wanting to ask, which is better? And I'm asked all the time by clients and friends, should I purchase joint tenancy? Should I purchase tenant in common? Or should I own my property by myself? I make this statement. The choice of type of ownership is usually based on the method by which the person wishes to dispose of their property, his or her property, upon death. So whether you buy the property by yourself, or they are joint tenants, or tenants in common, I believe the answer lies with how you wish your property to be disposed of on your death. So if you have 2 joint tenants, for example, husband and wife, and the husband says, I want on my death, I'm buying property now, husband and wife, and they say, on my death, I want my wife to get the property, then joint tenants. If the person says, on my death, I want my son to get the property, or I want to give the property to church, or I want to do X with that, then you may well be considering, if there's joint ownership, you're talking about tenancy in common. I hope I have clarified that, and I have made that clear to all of you. Joint tenancy, tenancy in common, and sole ownership. There are some cases, because I'm a lawyer, I tend to cite cases. The case law provides insight on how the courts handle disputes. I cited 2 cases. There's a case, Hall and Campbell is a 2020 Jamaican case. The parties held the property as joint tenants, Mr. Hall and Miss Campbell. And they were involved in a dispute. And then Mr. Hall now sought to realize his interest in the property, either by having Miss Campbell pay him for his half share or selling the property and dividing the proceeds equally. Remember, I told you that they were joint tenants. Miss Campbell, however, won at court, and she argued, for example, that she had dispossessed Mr. Hall of his interest through what we call adverse possession. So your whole property as joint tenant is not so simple. You get up and say, listen, John and Mary own the property joint tenant. I am wanting this person to buy me out. It's not as simple as that. The principle of survivorship, as I say, applies when it comes to joint tenancy. There's another case that I cited, 10 and Wilshire, and it has to do with the property rights under the Property Rights of Spouses Act and how the courts treated with joint tenancy property there. You could have a read of it at a later time, etc. So, my friends, all brothers and sisters, I looked first now at types of property ownership in Jamaica. Having done that, I want to look at some applications of land use and ownership in Jamaica. What are the things that I see or that we come across when it comes to land use and ownership in Jamaica? The first one I want to mention is an application to register land, especially outside of the corporate area, especially where we Moravians are, Westmoreland, St. Elizabeth, Manchester. A lot of land is owned that does not have a title. And so the question arises from time to time, how do I get a title for this piece? I share some thoughts. To register the land and to bring it under the Registration of Titles Act, the same act I was talking about with the Torrens system, the person who says that they own it, fill out what we call an NLA-AR1 form and submit it to the Registrar of Titles. Now, that application must be accompanied by what is known as statutory declaration, proving possession for at least 30 years, or 40 years without documentary proof. The supporting declarations should come from 2 individuals who would have known the land for at least 30 years. So if you live on unregistered land and you want to get a registered title, my Moravian friends, there is a process to get a title. That same duplicate certificate of title that I spoke of, that is indefeasible, that you can use to say, yes, this is my title. I can borrow money, I can sell, I can do anything I want because I know have proof of the ownership. So you have to fill out the form. Then you have to have what we call statutory declaration. It's a declaration by 2 persons who would have known the land and known you to say, yes, I know John Brown. I know that John Brown has been occupying this land for over 30 years. So I, Mary Thomas, duly say that I know the land located at XYZ in St. Elizabeth And I know Master John lives and occupies this land for the last 30 years. So the application form, 2 declarations. Then, of course, is now an up-to-date certificate of payment of taxes. That's the third thing. You need the application form, 2 declarations, and certificate of payment of taxes. And my friends, our brothers and sisters, so people love to go and pay taxes on your land, you know, because sometimes people out there feel that once you pay taxes for the land, you own the land. But also, if you're applying for the registered title, you have to have an up-to-date certificate of payment of taxes. So the declaration, the application form, the certificate of payment of taxes. Then a survey. So you have to get a surveyor to survey because you require a pre-check diagram. All right? So you need a survey diagram. And any other document that you have that shows that you own it. And of course, the government takes its taxes. You have to pay stamp duty and transfer tax unless it is exempt. So the application form, the 2 declarations, the certificate of payment of tax, and the pre-check plan from the surveyor, you lodge that application. And you pay the required fees, and it is sent to who we know in law as a referee of titles for review. When the referee of titles get all the documents and is satisfied that yes, this person owns it, living on it for over 30 years, pay the taxes, this referee of titles gives a conditional approval. And then you now will be required to publish in the newspaper for 2 consecutive weeks a notice. After you submit the proof of the publication of the advertisement you submit everything, they are submitted to the titles office, final fees are paid, and then the certificate title is issued. Then you have the piece of title paper in your hand, which is proof of your ownership. So let's back up. Application form. 2 declarations. 1 or 2 persons, that's 2 persons who say, yes, we know the land and we know that you have been on the land. Certificate of payment of taxes and a survey diagram. You pay all the taxes, you submit it to the referee of titles. The referee of titles, the official, review the application. If they are satisfied, they say, no, you must go and advertise in the local newspaper for 2 consecutive weeks. Once you do that, everything now is submitted to the titles office, and a title is issued to you under the Registration of Titles Act. I want you to bear in mind that in the event somebody come forward and oppose your application to get this title, they can lodge what we call a caveat, or they can also commence court action. And if that happens, it will prevent you getting your title. I hope I'm being clear. My friends all, this process can take you 12 to 15 months. So for all my friends living outside of the corporate area, living on land for upwards of 30 years, I am encouraging you to begin the process now to obtain a registered title. The LAMP Administration and Management Program, the Land Administration and Management is LAMP, is an initiative formed by the government to bring unregistered land, that's land where you don't have no title, in certain rural areas under the operation of the Registration of Titles Act. LAMP has significantly impacted land ownership in Jamaica. In 2018, LAMP merged with the Land Agency, and so you have 2 other entities there. But since 2000, LAMP has helped many Jamaicans becoming legitimate owners of their land by facilitating title. I believe you can do it yourself, friends, brothers and sisters, with the help of your justice of a peace and apply for your title, or you can go to a lawyer. I'm telling you, it's going to take 12 to 15 months. Or you can go through land. But I'm encouraging you, as I said at the start about land and what the ownership of land does and the power of it and what you can do with it, I'm encouraging you to seek to get your registered title. So that's the first application. The first thing that I want to talk about, land application to bring the land or to obtain a registered title if you don't have a registered title. I want to secondly speak about adverse possession because you can get land by what is known as adverse possession. Let me tell you what that is. Living on someone else's land without permission can lead to legal issues, making it difficult for landowners to enjoy the benefits of their land and potentially allowing illegal occupants to claim ownership rights. Jamaica has a system for registering land and parcel boundaries based on the English common law, but smaller plots often lack clear boundaries. Squatters, and when I talk about adverse possession, I'm talking about squatters on the other side, can gain legal title to land through what is known as adverse possession. So persons, not advocating that you go and squat on people's land, but I'm telling you that squatters can gain legal title to land through what we know as adverse possession. This means that if a squatter has been in continuous open possession of privately owned land for at least 12 years, they can apply for legal ownership. When it comes to government land, though, they have to squat on it for 60 years. In Jamaica, squatters' rights are primarily governed by what we call the Limitation of Action Act and the same Registration of Titles Act as well as relevant case law. I cited Section 3 of the Limitations Act in the paper and Section 85 of the Registration of Titles Act. The possessor, in addition, the possessor, which is a squatter now, must demonstrate that they have maintained uninterrupted, they're on the land, uninterrupted, undisturbed for the 12-year period. And their possession of the property must be so evident and well known that it would serve as general notice to the paper owner that they are in possession of the property. So if you own the land and squatters come on it and they are on your land for 12 years, private land, in open possession, so it is evident they can acquire title to the property. This implies that the squatter's tenure must be visible. It's not a secret. And it must have been open and well known for 12 years, as I said. And when it comes to crown lands, government lands, 60 years. There are two cases that I mentioned in the paper. One, there's a case named Recreation Holdings Limited and Carl Lazarus. It's a Privy Council decision. That case, the parties were in dispute over a 9-acre piece of land in St. Thomas. Mr. Lazarus had been in possession of the land for over 12 years, during which he fenced the property. He put structures on it and he planted trees. The main issue before the court was whether he had acquired ownership of the land through adverse possession, despite the land being registered to Recreation Holdings Limited. So the company owned the land. Mr. Lazarus go on the land, was on the land for 12 years. In build structure on it, he planted trees on it, he fenced it. And the court ruled in his favor. The court found that he had met the requirements for adverse possession, having been in continuous and undisturbed possession of the land for the requisite period. There's another case named Peter Perry and Carol Baugh. In that case, Mr. Perry was a registered owner of a property in St. Catherine. Miss Baugh had been in possession of various parts of the property for over 12 years. And the issue was whether Miss Baugh had acquired ownership through adverse possession, despite Perry being the registered owner. So Mr. Perry owned it, Miss Baugh lived on it. Undisturbed for 12 years in open occupation. The Court of Appeal upheld the parish court and found that Miss Baugh had met the requirements for adverse possession by being in continuous and undisturbed possession for the requisite period. These two cases, my brothers and sisters, friends, highlight the importance of adverse possession laws in Jamaica and the need for property owners to be vigilant in protecting the land from squatters. The legislation in this case law illustrates that squatters must demonstrate continuous and exclusive possession of the land without the owner's permission to claim adverse possession. This involves providing evidence of their occupation and use of the land. So you own the land and you have your title. You allow people to openly live on it for 12 years. They can acquire title. These are registered land. So what I urge all the property owners in Jamaica, and I advise them to take proactive measures to prevent squatters from claiming your land. This includes regular inspection and making or taking legal action to remove squatters from early in the day. Adverse possession, people can acquire your property. I urge you to be diligent. 12 years is not a long time. One of the things that I know too is that, Jamaicans, they go all over the country. Some people, they will go to Portland and they see a piece of land and they set up shop and they live on it. And after a while, they apply and acquire title as their own. So if you own land, be vigilant. Somebody squat on it, get them off as quickly as you possibly can. But guess what, my friends? The Moravian Church, our church, has been unfortunately less than vigilant. In 1884, as you know, our church was incorporated by an act of parliament. And I can tell you that on the incorporation in 1884, we had a listing of all the lands that the church owned in Jamaica at the time. In Little St. Elizabeth, for example, we had 469 acres. Today, we can claim ownership of less than 10%, as many persons have acquired registered titles to most of the lands at Litties in St. Elizabeth. So of the 469 acres left, I don't think we have 20 acres left. Squatters have taken over and they have acquired registered title. And remember at the start what I told you about registered title. I spoke to you about the indefeasibility of title. So we can't come now and say we own it. We can't. They own the land. This is also the case in relation to many of the parcels of land in parishes such as Westmoreland, St. Elizabeth, and Manchester. We are losing our lands. As a church, we need to be more vigilant. Successive governments have recognized the need to address this issue and have begun implementing programs to regularize informal settlements and provide residents with secure land title. By formalizing land rights in these areas, the government's hope to improve living conditions, stimulate economic growth, and prevent further legal disputes over land ownership. My brothers and sisters, it's 7:15. We're going almost an hour. I have to go quickly. I thought that it was a teaching session and therefore we could finish this in an hour. But let me try and look at the other things. So I was looking at ownership of land, how you own land. Then I was talking about adverse possession and how people can get land. Then I looked at what you call lost title application. And I'm saying in the event you lose your title or it is destroyed, you can make an application under the Titles Act for a lost title application. We call it. The application is a statutory declaration that must include the particulars of the land, the title reference, the lot, the value, etc., and you lodge that to the titles office, and you can get a new title. And usually, and you have to advertise also in the press, and usually a new title will take you 3 to 6 months. So if your title is destroyed or you lost your title, you can't find it, there's a process for which you can get a title. And you can do that. You don't have to go to a lawyer to do that, but you can also use a lawyer. Then I spoke in the paper about, I did in the paper about transmission application. When the owner of a piece of registered land dies, the property is what we say vested in the personal representative of the deceased. So for example, the person leaves a will and dies, the executor, the property vests in the executor. And what happens though is that on an application for probate being made, the executor is registered on the land. And then the name of the executor will do whatever it is that the testator, that is the person who owns the land, wants to happen. That's what happens. That's where I talk about transmission. Additionally, fees needs to be paid, etc., when you come to those things. So transmission application, I'll deal with quickly. Then you can lodge caveats. What are caveats? A caveat is a notice that is served on the register of titles, which acts as we call as an injunction, barring the registrar from registering any dealings in respect to a property. The caveat must include the owner's name, etc., and what it is that you can lodge caveat for, especially in the corporate era now. In strata corporation, if you don't pay your maintenance fees, the strata entity, the management committee, can lodge a caveat on your property. And if a caveat is lodged on your property, it bars you from dealing with the property as you feel fit. You can also lodge a caveat when you're containing that you have rights under a will or a trust deed, as we say. You can have a caveat lodged. Or if you say that you're a purchaser under an agreement for sale and the vendor is trying to sell the property to somebody else, you can also lodge a caveat. A caveat is a notice to the registrar barring dealings with the land by the owner. So you have caveat. So in context, my friends, we have firstly, ownership, past ownership, meaning application to register the land if you are on unregistered title. Then I say you can obtain title from by adverse possession. If you're a squatter, you can get a title. Then I'm saying you can, another application is a lost title. If you lose a title, you can apply for a new title. Then I tell you what happens when you die in relation to property that you own. Your executor is registered on your title. Then you can lodge a caveat to prevent people from dealing with the title. And I want to briefly mention modification of restrictive covenants. And let me just tell you what it is. On the face of your title, there are covenants that restrict the use of your land in a manner that benefits all the owners in a subdivision, for example. These include distances of building from the property boundaries, prohibition of subdivision of part of the land, or use of the land as a church, among other things. So on your title, there are these restrictions we call restrictive covenant. So if the owner of the land desires to use the land in a manner that is restricted, then you have to make an application to the Supreme Court now for the modification or the discharge of a restrictive covenant. And in the paper, I deal with how that process is done, as well as time frame. When it comes to land also, you are the owner of a property, and sometimes you have tenants on your property, and you require to move the tenants from the property. I deal with a section of the paper about recovery of possession. The law requires that you must serve a notice to quit. And also the law says that the notice to quit must be a reason that is in the act. So you must say, oh, I own the property. You have a tenant, the tenant, you want the property out, the tenant out, you have to serve a notice. You have to state a reason in the notice. Reasons include, for example, you want rent is owing, or you want it for your own use and occupation, or you want to repair it, stuff like that. Regrettably, the reason that you want to sell the property is not a reason under the act. So you can't say you want to give your tenant notice to quit the property because you want to sell the property. That's a no-no under the act. And in the paper, I also deal with what you have to do. Essentially in Jamaica, if a tenant, on being served with a notice to quit with a reason, does not vacate the premises, you have to get a court order. And when you come to court, you have to prove at court the reason why you want it. So for example, yes, the rent is owing still. Yes, I need it for repairs. Yes, I need it for my own use and occupation. So you have to go to court to get a court order. If you have a tenant and the tenant does not vacate the premises, even after you serve a notice to quit. And even after you get a court order, if the tenant still remains in occupation of the premises, you have to now enforce, get a bailiff to get the person off the property. The next thing I dealt with in the paper was sale and purchase of land. And I dealt with it in much detail. I spoke about the agreement for sale and what is encapsulated in the agreement. So you have a vendor, you have a purchaser. Usually, when it comes to sale and purchase of land, I strongly urge my brothers and sisters that you seek the advice of an attorney in terms of dealing with it in Jamaica at this time. How to acquire or dispose of a property. And I dealt with it in detail in the paper as to what it is that needs to be done. And I spoke about transfer tax, and which is 2% of the value of the property. Stamp duty, which is now I understand is $5,000. Who pays the transfer tax is the vendor. The stamp duty is borne equally by the parties. And when you pay a deposit, they use all those things to pay out of the taxes and stuff to pay from it. And in a sale today, my brothers and sisters, friends, it can take 45 to 60 days if it is cash. You're buying somebody's property, there's a registered title, 45 to 60 days cash. If it is a mortgage, if you're taking a mortgage, then you're looking at 90 to 120 days. These things you need to know so that if it is that you need the money for something, you need to know that if the person buying your property is taking a mortgage, then you're not getting your money for 120 days. All right? Minimum 120 days. If it's a cash sale, you talk about 90 days. And I strongly recommend that if you are purchasing property, that you seek the advice of a lawyer. I also address a question of mortgages. And a mortgage is an agreement where you as a borrower uses your land, the same title that you get under the Registration of Titles Act that is issued. You use it to borrow money as collateral for making it easier for life. You borrow money to even buy property or you borrow money for something else. And so I dealt with that and what is necessary there. I think that was most of what I dealt with under the property section in relation to the paper. So my brothers and sisters, I think I will pause here to give you an opportunity to catch your breath before I move into the second section, which is estate planning. And during the break, you could tell me if I'm going too long and you need me to stop. All right, over to you, Sister Veronica. Let us just take a break now. I can take any questions that deals with the property aspect. And then on the second segment, I will deal with estate planning, making wills, etc., etc.
Our moderator, Sister Chantal, will continue with this section. You're on, Sister Chantal, right?
Thank you. Yes, I am. Thank you, Sister Veronica. Brothers and sisters, yes, Brother Lowell has shared a lot with us so far. Do we have any questions for Brother Lowell at this point before he continues? Sister Lorna Morgan, I see that your hand is raised.
Sister Lucinda Pierce, hand is
Yeah.
raised.
Okay.
Thank you, Sister Chantal.
Sure, go
Two
ahead.
questions. One is, how will we get the paper?
I'll answer. We'll
go
have
ahead,
a
Sister
link in the
Veronica.
chat before we end, where you can go and download. If you can't do that, you can put your email address in the chat and I'll send it to you.
Okay, thank you. And
Sister Veronica, just before, I just checked my phone and I'm seeing a number of persons who are saying to me that they cannot get on. Are you at capacity? Can you
YouTube.
yes.
There's a link in the chat. They can go to YouTube.
Okay.
It's Moravian Church Demi. Moravian Church in Jamaica, Demi.
Okay.
All right, thank you. Sister Peart.
No, I'm not. I have a question for Brother Lowell.
Okay, go ahead.
I know he mentioned about ownership. He said sole ownership, I think, and joint tenancy, and another one. I don't remember the name of the other one. I understand.
Tenant in common, sister.
Right. I understand the difference. But what I don't understand is how you get into each one. Okay, three of us buying a property. How do we decide if it's joint tenancy or tenanting the other one? I don't understand that part.
All right, let me clarify you, sis. Remember I said, I think the decision as to whether you're going to be a joint tenant or a tenant in common. Well, first of all, back up. I said that if you're going to own property, you need to think seriously about it and how you want to own property. And then secondly, that is where you want to buy it yourself, joint or jointly. If you decide jointly, then now to determine whether it's joint tenants or tenant in common. And I'm saying to you, the critical decision is not which is better, but how do you want that property to be disposed of on your debt? What you want to happen to that property that you own. So if you're buying the property joint tenancy, you just indicate that and the title would come out on the agreement for sale, it would say joint tenancy. Or if it is tenant in common, it will say tenant in common. But
so you made the decision then.
You made the decision on the purchase. And you determine whether or not you want joint tenants with the other persons. Typically, though, I know, for example, that in a lot of cases, husband and wife, they buy property joint tenancy.
Okay, thank you. Thank you.
But it doesn't have to be. Okay.
Okay.
Thank you very much, Sister Peart. You may go ahead.
Yes, thank you. Thank you so very much. Kudos to Brother Lowell Morgan. Wow. Too much to absorb.
I'm sorry
So
about
we
that.
have to ask, we have to ask you to teach us some more, because these are very important bits of information that we need to know, including the Moravian Church. Did you say Torrens system or current system? Is it Torrent from Australia?
Yes, yes, it is.
Okay, thank you. I'm glad about the way you framed the lecture with, who is really the ultimate ownership of land? Because deadlift has been really making people kill one another. I just want to underscore that with the assurance that we have that even if we don't have any land here on earth, Jesus says in John 14:3, I go to prepare a place for you, and I will come again and receive you unto myself, that where I am, you may be also. So we're sure of that land, and sometimes we sing, my home is in heaven. Again, in Hebrews chapter 11, verse 10, the author says we are looking forward to the city with foundations, whose architect and builder is God. Now, sir, one of my many questions, which I won't have time to ask, one is, which takes precedence, the joint tenancy or the will? For example, if you have a family and one member's name is on the land as joint tenant, but the will has 5 members on it, that the land is to be shared, the property is to be shared for the 5 persons. Which one takes precedence?
But remember now, I'm saying under joint tenancy, the principle of survivorship applies. So
Yes.
if 2 persons own the property and one died, it doesn't matter what that one person says in his will or her will. The entire property goes to the other owner.
Okay, I understood it like that, but for reasons that I won't say, I wanted you to emphasize.
All right.
Okay.
So 2 persons own the land. Two persons own the land. One person in a will says, I devise my property or my interest in the property to 5 people. The person dies. Those 5 persons can't get anything because survivorship principle applies. So the surviving owner gets the end of the land. It doesn't matter what the will says.
Okay, thank you. One last one. It's about the Moravian Church and for seeming lack of vigilance, we are losing property. I don't know if we have lost that little property opposite to Ballard's Valley School, but I see some building going on there, and I was always told that it belonged to the Moravian Church. Would you say the same thing about Maroon lands and the government, succeeding governments, that they have been less than vigilant? So what's happening now in a compound is as a result of lack of vigilance? It's not a political thing, it's just for information.
I am not sure though. And the plot of land in Ballard's Valley that you spoke about, we own that, we sold it.
Okay. Thank you.
All right.
Thank you, Sister Peart. I'll share a question in the chat, Brother Lowell. The question is, if the title is owned in joint tenancy and one person has died, is it necessary to remove the name of the partner who has died from the title?
Yeah, what usually happens when one person dies, yes, what we call is, the death. It's always necessary if you're going to do anything. So for example, if the surviving owner wishes to sell the land, at that time they have to note the debt. So sometimes it's recommended that if two persons own the property, and one dies, that you note the debt of the person on the title. It's not a simple application to the register of title, attaching the death certificate.
Okay, thank you. There are 3 hands that have been up. We'll take these 3 and then Brother Lowell will continue. Sister Failure, Sister Lorna, Sister Charmaine.
Good night, good night. Interesting presentation. Under the Registration of Title Act, you mentioned 2 things. You talk about the 12 years, which I understand, adverse possession, undisturbed, and you can get a title. But before that, you mentioned something about 30 years. I'm not sure I understanding that 30 years before you can get a title.
All right,
Thank you.
Let me clarify again. Boy, I'm not doing so well as a teacher. All right, when you have unregistered land, that is, you don't have a title for the land, and you want to now obtain a title, all right, you have to get 2 declarations from persons who know the land for 30 years to get the land registered. That's that's unregistered to registered land.
Okay.
And I'm talking about adverse possession. I'm presuming there is a registered title. I'm saying there's a registered title and somebody come on your land and live undisturbed for 12 years. They can get title to it.
Thank you. Clarify. Thank you.
Sister Lorna, Morgan, you may go ahead.
I think she asked her questions already.
Sorry, yes, I asked my question already.
Okay, Sister Charmaine.
Yes, my question, sorry about that. My question is almost a follow-up to Sister Failure's thing, because I remember Brother Morgan cited something about somebody having a property with their title and somebody lived on it for 12 years and they won. Now, if I have my title and I have been paying my taxes every year on the same land, and I can prove that I'm paying my taxes, but I wasn't even aware that this person is on the land for these 12 years. Can they still, if I go to court and I can say I have my title and I pay my taxes every year, can that person be paying taxes on the same piece of land, and how would the court award them to stay there?
If all you're doing is paying the taxes and nothing else, I'm saying that you have to be more vigilant. You have to go and visit the land. You have to be vigilant, because if you don't, you're going to lose it. Or you can't do it.
Thanks. Okay, thanks.
Thank you, Sister Charmaine. Brother Lowell, if you are ready to continue, you may do so.
Okay.
Just before you continue, Brother Lloyd, there's a question that I put in the chat, but see nobody saw it. Let's say a couple lived on a property for over 50 years. The property was acquired before either of them came together as, they were friends, so to speak. Or let's say before marriage. Now it's a registered title, but the wife's name was not on the title. The husband died. How can the wife get her name on the title?
So the husband alone owns the property.
Yes, that the husband bought the property before
they get married. Well, I think another legislation comes into play under the Married Women's Property Act. If it is the principal family home, my understanding is that the person is entitled to a minimum 50% of it. But I think through a process, did the husband leave a will?
No. Yes, a will was left, but not for that that property.
Well, that property becomes under intestacy, and I believe under the rules of intestacy, the wife would also be entitled to it. So what I think that needs to be done is that the estate needs to be administered, and the action follow from there. But it can be in a simple solution. It can be.
So you mentioned before about declaration, application and declaration. So that person would have to get person.
No, man, you have a registered title already.
Oh, okay. Okay.
There is a registered title already. It's not. I said the declaration is when you're moving now from unregistered land to get the title for registered property.
Okay. Okay.
All right, let me go, brothers and sisters. I shouldn't keep you out until 8 o'clock. All right, key elements of estate planning. During our lifetime, we accumulate numerous assets. We accumulate money, jewelry, painting, shares, and of course, property. However, these assets cannot be taken with us when we die. So what do? You plan. Upon death, all these assets that you would die possess of forms part of your estate. In arranging how to dispose of these assets, you are estate planning. So that's what we mean by estate planning. How you plan to deal with the things that you own or you have acquired during your lifetime. It's a process of arranging for and managing the disposal of an individual estate during their lifetime. It includes making a will, transferring assets during one's lifetime, and holding property jointly. So a part of estate planning is making a will is just one aspect. You can hold property jointly or you transfer assets during your lifetime, because some persons prefer to say, look, better I give my children what I have during my lifetime rather than after death. It is important to note that when you fail to plan for your estate, the government will step into your shoe and determine how your assets are to be distributed under what we call the Interstate Estate and Property Charges Act, whereby there is an order of priority for those who will be entitled to benefit from your estate. The first person is your spouse. So if you die and leave no will, then your spouse is the first taker. Then your children, then your parents, then your siblings of the whole blood, and then half siblings, then aunties and aunts, etc., etc. And if there is nobody, the government gets what it is that you have. I suggest also that you seek professional advice and guidance from lawyers on how to structure your estates, etc. I spoke about probate and letters of administration in the paper, but for our purpose, I want to just zone in on the provisions for will and requirements. One of the primary components of estate planning is drafting a will. Will is a document that outlines how your assets should be distributed upon your death. In Jamaica, it is essential that your will is properly executed in writing and witnessed by two persons who must be present when the testator at the same time to be legally binding. So, the will must be in writing first, my brothers and sisters. And it must be witnessed by two persons. But those two persons must be present when you sign. Too often, I have come across people say, yeah, man, me leave the will. There is a will. And in recent times, I've had about 4 or so persons come. And when we look at the will, it is invalid. It is invalid because 1, the testator signed January 2. 1 witness January 2 and 1 witness January 4. Invalid. The 2 persons who are witnessing the will must witness at the same time. And then I know in law, again, neither a beneficiary or the spouse of the beneficiary must witness the will. So if you're making a will and you want to leave some stuff for me in your will, you're leaving money for me, or a house for me, or land for me, don't ask me to witness the will. So neither a beneficiary or a spouse of the beneficiary should witness, because if they do, that particular gift is void. All right. As I say, you can get a lawyer, but you can make a will The Wills Act outlines a requirement, which must be in writing, then signed by the testator, 2 credible witnesses. The testator must be 18 years and over. So if you are 17 or 16, no point. You must have the mental capacity to make the will, and you approve of the contents of the will. By the way, the person who is witnessing the will, we call him a testing witness. They don't even have to know the contents of the will. What they are witnessing is your signature. So they don't need to know the contents of the will. They don't need to know anything about it. They are witnessing your signature. You must be 18 years and over. If there are any alterations in your will, it must be initialed. If you don't do that, then you may have problems. The next thing that is important is that the will is automatically revoked by marriage. So after you say, I do, then that is it. Well, once all the other formalities of the marriage are completed, that will is revoked. You have to make a new will. And time again, you have to deal with that. Will was made, then the testator get married, the will is revoked. Marriage revokes a will. If the testator, that is the testator or the testatrix, testator, the man, the testatrix, woman, destroy the will by burning or tearing or doing some act to show an intention to revoke the will, the law says it is deemed revoked and no longer valid. I dealt with the process of administering the will, and I say that you must set aside funds for expenses, create a dedicated bank account, obtain life insurance and all those things to help you in terms of the administration of your estate. And if you die without leaving a will, as I say, you die intestate, and there's a prescription as to how it is that your assets should be divided. And I'm urging you all at this point, I plug in for my church. I'm encouraging all of us on the platform, most of us will be 18 years and over, to make a will. And I'm also encouraging all of us to remember the Moravian Church in Jamaica and Cayman Islands, our beloved church, in your will. That's what I wanted to say about will. I can take questions on that after. I also dealt with trust applications and powers of attorney. And I mentioned something about guardianship. If you have minor children, you should appoint a guardian in your estate plan. And this ensures that your children will be cared for by someone you trust in the event of your passing. And we can help you to legally designate a guardian and include this in the provision of your will. So the testator or the testatrix can say what should happen in relation to their children. I've also discussed power of attorney is a document that grants someone the authority to act on their behalf. To grant this power of attorney, you must be of sound mind and in a position to ratify one's decision made on your behalf. And I say a power of attorney can be general or limited. And importantly, it can only extend to one's, it can also extend to your health care. And so, but and the power, a power of attorney, as I say, can be general. It can be also specific. So you can draft a power of attorney. You can give personal power of attorney to sell your car, to sell your house, to deal with health issues in relation to you. It's an authority that you're giving to somebody, but you must be of sound mind and authority to do things on your behalf. Once you die, the power of attorney ceases. It's dead with you. One of the things that I know that is happening in relation to powers of attorneys, especially bank, you grant a power of attorney for somebody to draw money from the bank for you, etc., etc. The person take the power of attorney to the bank. I know that in this day and age, the bank is very scrupulous, not scrupulous. The bank is very particular, and the bank will call the person. Did you grant a power of attorney to John Brown to draw money on your behalf? Things like that are happening. So you must be of a sound mind. It's a legal document, sign up, witness, stamped, recorded at the at Spanish Town, and you give authority to people to act on your behalf in certain circumstances. So I discussed that in the paper. Many Jamaicans, I think, overlook the importance of integrating land rights into estate planning, as real property is primarily held in fee simple. However, real estate ownership can be achieved through various severable instruments. So, for example, you can have a 99-year lease, and I'm saying that is a long-term lease that you can take care of and consider in your estate planning. I think, in summary, I suggested a comprehensive understanding of different types of property arrangements and rights associated with them is crucial in order to inform decisions about estate planning. And sometimes I'm saying you should seek professional advice. You could seek the input of a lawyer. And finally, I concluded in the paper, so almost 8 o'clock, persons can exercise rights of land ownership by buying or selling, acquiring by adverse possession, or bringing unregistered land under the operation of the Registration of Titles Act. Property can be either owned either solely or jointly. If persons decide to own jointly, consideration should be given to whether they should want to own as joint tenants or tenants in common. Should property disputes arise, the landowner or anyone claiming an interest in the land must always have recourse, and I suggest when these disputes arise, you seek to resolve them through mediation rather than go to court. As assets that you have acquired in your lifetime will form part of your estate upon death. And as such, the necessary arrangements must be made for the disposal of assets sometimes during your lifetime. So my brothers and sisters, that is it in a nutshell. I hope it was a teaching session for most of us. I hope I would have communicated something to you that would be lasting, and I am still online to take any other questions that you may have. It's way too late now. It's almost 8 o'clock. I thank you for your time and for your attention.
All right. Thank you, Brother Lowell. There has been a burning question since the first Q&A session. And the question is, a land was purchased over 30 years ago. Survey was done and a diagram was given and signed by a JP. The husband died. How can the wife get a title because a title was not given upon purchase?
You're assuming that, so there was no title, so somebody wants to bring I think the person would have to start over. There's a survey diagram I think they may have to do over the survey, apply for the title. I spoke about the form that you need to fill out, and you apply for a title, get the declarations, get the survey diagram, pay the taxes, certificate of payment of taxes, submit the documents, it goes to the referee of titles, and then the referee will issue instructions to issue notice. So I would say now, the person who started the process died. I think the spouse can continue the process or start over the process, because I think also that that survey diagram may have expired.
Okay. Thank you.
I hope I answered that person's question. Did
Brother
you
Lowell,
clarity from?
Brother Lowell,
Yes.
what's the difference between a deed of gift and a will?
A gift.
Deed of gift. Deed of gift.
My understanding of deed of gift is a gift. A will is a document that outlines what it is that should happen to your estate upon your death. That's what is recorded in a will. A deed of gift, I am not sure if they call that a will, but that to me is a deed of gift. Dominic, the conveyancer, that's a piece of land that's given to somebody.
Some persons always, I heard a person saying, instead of making a will, they give like a deed of gift, where the person who they're giving the land to or whatever will be able to occupy the land, even if the person, the testator, the person who gives the land or whatever it is still alive.
So to me, well, that's not an absolute gift. Is it a permission to just occupy a land?
No, it's like like, let's say a parent then have land, And instead of making a will, they said, give a deed of gift, give them as deed of gift. Or maybe somebody was taking care of somebody and the person wants to give, you know, a piece of land to that person. So instead of writing this, because I think there's also a form that states deed of gift.
Okay, I'm not sure about that, but I will investigate that. And that's Sister Ratchy, right?
Yes, sir.
Right, and I will get back to you on that. I'm not so sure about that distinction.
After JP, I've seen those forms. So that I'm asking what's the difference between a deed of gift and a will and a will.
Okay.
All right, thank you, Sister Ratchery. Before I take
Brother Lowell, good job, Brother Lowell. I have a question for you. This Brother Winston Peart here.
Brother Winston Peart.
How you doing?
I am well.
I have a question for you. And we know that the executors, my tongue tied now, have an important role to play.
Yeah, I did mention that, and I should have said to you that when you're making the will, we recommend that you appoint at least 2 executors, people who you trust and have confidence in.
Okay, so the question I have on that, what if those executors die or because of mental capacity or whatever, they are no longer able to carry out their responsibilities? How do you go about that?
My recollection, that's why you name 2 executors in the first place.
Mm-hmm.
And I think that the executor of that executor becomes your executor. I think that is what it is.
Mm-hmm.
Oh. Okay.
Okay.
Deed of gift, right. Mm-hmm. And also too, I know that there are proceedings in court, especially because I'm a litigation person, that if the executor do not take steps to have the will probated, that you can force them or you can have other actions taken in relation to the executor.
Yeah.
But the important thing, when you're making the will, you should name 2 executors. I think I mentioned it in the paper, at least 2 executors and people who you actually trust.
Mm-hmm. Yeah, the follow-up, the other question I have, and I'm not sure you touch trust, because there's will and there's trust, and I think a lot of people are going the trust route. I know certainly here in the US.
My understanding of that, though, is that some of those trust rules that applies in the United States doesn't apply in Jamaica at all.
But you do have trust also.
Yes, you can have trust here, but some of the trust rules that you have there are legislation based and they are not applicable in Jamaica.
Mm-hmm. Okay.
Ask a question, please.
Before we take that question, 2 hands have been up. Sister Charmaine, Sister Janelle, will take you, Sister Peart, then Sister Lorna.
Okay, thank you. With regard to the executors, I was made to understand that it's a minimum of 2 for the reasons.
They can have 1.
For the reasons of mental deterioration or death, it was always good to have. Yeah, 3.
You can have 3 as well.
Okay. And the other thing is,
let us clarify, Mrs. Pate, just before, let us clarify. If you have 1 executor, it doesn't nullify your will enough. You just have 1 executor. But you can have 2 executors and you can have 3 executors. One of the things that you must remember also is that executors are entitled to fees in total of 6%. So you have to bear that in mind as well.
That's what I was going to ask. Some persons say, some professionals say that it's advisable if your children are in good stead for you to make them your executors if you have like 2 children. But if you have 6, you can't do that. But if you have 2 children, you can make them your executors so that the 6% or 7% remains within the family.
Yeah, but if that shouldn't trump if the children, you're assuming now that the children are responsible and pass the and proper test. Other than that, I don't think you go, it necessarily has to be the children. But what I'm saying is people who you trust and who you know will carry out your wishes. Quite often, I can tell you, I see it, Mrs. Spirit, that executors are children and they don't bother. They just fold up their hand and they don't do anything. And what that does sometimes is to create division amongst the children. Right now, I'm dealing with 6 children, 2 children are executors. And they are the children who are the executors are not doing what they are supposed to do and has left no frustration for the other 4 children. Especially also when you have property involved, you could just imagine you have property involved and where the executor living on the property, but the property should go to others and stuff like that. So the question is, as to executor, is a matter of trust most importantly, and not necessarily children just to save the money in the family.
Thank you.
Yes.
Sister Charmaine.
Thank you, Sister Chantal. My question is this. Is there a time frame with the lawyers when they have a will to approbate the calling word or whatever? Why is it that sometimes they take so long? Is it the lawyer or what?
Sometimes
Just
it's not
trying
the
to
lawyer.
understand.
Sometimes I can tell you most times, sometimes it's the lawyer, but sometimes a lot of times it's not the lawyer, it's the system, because the probate application has to go to the court.
Mm-hmm.
But I have done a probate in 6 months in a matter in which I'm the executor. And I had the probate done in 6 months. You can get it done in 3 to 6 months, but sometimes it continues for years and years. I know one now that's continuing over 2 years because it has to go to court, and sometimes there are errors, things needs to be corrected and things. And sometimes the court is just overloaded. So sometimes it's not the lawyer at all. Sometimes it's a system. It's an application in court. And as you know, many applications in court can take a lot of time.
Okay, thanks, sir. Well, maybe I'll have to find out the details. Thanks a lot.
All right, thank you, Sister Janelle Powell.
Hi, thank you very much, Reverend Chantal. And Brother Lowell, thank you for that presentation. I'm looking forward to reading the paper. I wanted to, well, just ask if I could be permitted to respond to the question about the deed of gifts, since in my practice, I do handle a lot of conveyancing, so I could distinguish between it and the will for whoever needed it.
Who is speaking?
This is Janelle Powell.
Oh, hi, Counsel. Good. Yes, go ahead. I appreciate it.
Okay, so the deed of gift is, as you had said, Brother Lowell, a means of giving a gift. That operates inter vivos, as we understand that term to mean while the person is alive, as opposed to the will that only takes effect on death. So if you want to give, it doesn't have to be a family member, but if you want to give a property to your children while you're alive, you can do that. You can go get the deed of gift form, fill it out, and then that can be taken to title's office after, it's stamped and transfer taxes paid and all of that, for them to get the title to whatever property it is while you are alive. So it would pass from you to whoever it is you're giving it to as a gift. So that's the difference. I'm hoping that Sister Ratri is okay with the answer.
Yes, I'm listening, and thank you very much, because that was my understanding.
Thank you for that, Counsel. I appreciate it.
No problem.
Somebody in the chat says, can a person on deathbed divest his or her assets using video? But remember, I said it must be written. For the will to be valid, it must be written. So I don't think that would work. That's somebody asked in the chat. All right?
Mm-hmm.
Not the video thing, not going to work. It has to be written. The Wills Act, it must be in writing.
Okay, thank you, Brother Lowell. I see 2 more hands, Sister Lorna, and I see Sharon's iPhone.
Thank you, Sister Chandal. Another question I have. You spoke about the spouse automatically getting. Well, the question is, does the common law wife or husband have the same, what's the word, as the wife or husband?
You mean, but
So if
remember,
we're in a common law relationship,
you
so
can be you can be declared a spouse if the persons are living for what, 5 years. So that's a spouse.
Okay.
All
Okay. So it's just after 5 years. So if it's less than 5 years, there's nothing for the common law wife or husband.
I don't think there'll be a declaration for spouse. Nothing for the person. But I should tell you though that there is an act called, I think this is the Inheritance. I think this is the Inheritance Act that permits someone who was not provided for under a will to still benefit from the estate. So if a testator is accustomed to, for example, take care of a mentally challenged child and in the will does not leave anything for that child can petition the court and get something from the testator's estate. I suppose that in certain contexts, common law spouses may well benefit under such application. It's called the Inheritance Act, and I didn't really deal with it under that in the paper.
Brother Lowell, I came upon some interesting papers the other day from my grandparents or maybe great-grandparents. Some of them is hardly readable anymore, but some of them says like, I sold this piece of land to Mr. So-and-so for 30 shilling. I sold this piece of land to Miss Veronica Sutherland for 10 shilling and so on, but it doesn't name whether it's a 1/4 acre, a 1/2 acre, 10 acre. And as I read that, I just wondered, what if these people never pursue to the point of getting a title or anything? Could I, 70 years later, claim possession of these lands unless I know that they were really occupied and owned by them? Because all I saw was some little receipt handwritten that Mr. So-and-so was sold a piece of land, and the land does not talk about any boundaries, any quantity, anything like that.
Are you in possession? Are you in possession?
Huh?
Are you in possession?
Well, well, some of those land would be in adjoining where we are in possession, but you know, so I guess the land, I guess a lot has to do with boundaries and all of that.
Yeah. Well, I think on that sounds a little bit complicated, and I think an attorney can provide you with greater guidance on that, because it may well be possible for you to acquire titles for those properties.
Yeah.
All right, thank you, Brother Winston. I don't see any more hands. Do we have any more questions for Brother Lowell? Any further questions?
Brother Lowell, this couple, they were together, they married for over 6 years. The husband died. Can relatives force the wife off the property? It's a family property, large quantity of land, but that's the husband occupied. Can the family members force the wife off the property since they were married for over 6 years?
But who owns the land?
We call it family land, but you know.
Oh, it is family. Yeah. There's no registered title or anything?
They have title, yes, they have title.
All right, now. So, and the spouse is on the land. But I think
yes, sir.
And you're saying that the person didn't leave a will?
No.
Well, what the spouse should do is to get the estate administered. Or at least try to get the estate. Oh, but the land didn't belong to the spouse.
Alone.
Oh, Well, I think she may well be entitled to whatever an interest in what the husband had.
Right. That's my advice.
That's what she would have been entitled to.
Yeah, yes, sir.
Husband
But
was entitled.
but the family, let's say no individual in the family can force her off the land.
I would challenge that if I were her.
Okay, sir. Thanks.
I would say that my husband was an owner of this property. On his death, I have acquired his interest, and therefore you can't get me off.
Okay, sir. Thanks.
But she should take steps to regularize the position.
Okay, sir.
And
Thanks.
get the security of tenure that I spoke about earlier.
Thank you, Brother Lloyd.
Good.
I have a question, please, Madam Chantal.
Yes, Brother Kevin, you may go ahead.
You, good night, Council. Thank for your presentation, sir. It was very, very well done. I know it's way past your bedtime, so let me proceed very quickly.
Yes, Brother Kevin.
An example, a husband and wife write different wills. Husband want to give something to, both of them have same children, but want to give some to his parents and so. Both of them dies the same time. Car accident, both of them die. Now both wills, they have difference in the will, and they're going to be probated. Wife wants something for her parents and perhaps sibling, and husband wants something for his parents, sibling as well. How would that work?
No, I think there are rules in law as to if both persons, I think there are rules as to what would happen if the persons own, I'm assuming they own the property joint tenants, right?
Correct.
Right. I think there are rules as to who survived what, as to who died before what, as who dies first. Because remember now, survivorship applies. So it is the person who died last. It is that will that would have precedence.
So it would be at the hospital and the person that takes the last breath that will take precedence.
Right. All right.
Okay. All right. Thanks, Chief.
That's interesting.
Yes.
Thanks, Brother Kevin, for that question. Any final question for Brother Lowell? It is now 8:12.
Yeah, but I thought it was a 1 hour thing. Sorry, I spoke too long. I'm sorry.
No, it was a great presentation. All right, if there be no further questions, Sister Veronica, can you please come and extend thanks to our presenter and all necessary parties for this evening's lecture?
Good evening, my brothers and sisters. It has been a wonderful evening, I must say.
Yeah.
Before I thank Brother Lowell, for those of you who are asking for the paper, there's a link in the chat you can download. And for those of you who can't do the download, put your email in the chat. I will email the paper to you. And I'm also going to ask Brother Lowell's permission. I see one individual saying that it was a lot to take in for senior citizens. If maybe we could summarize something in a brochure format, or maybe several, that we could give out from Demi. Of course, we will copyright it to you. Is that something we can do?
Yes, I think maybe that's a step to provide summary of the various headings, like to apply for a registered title in one document.
Yes.
How to apply for a lost title, another document. Procedure for a will with a sample in another document.
Right.
Yes,
that's
maybe
what I'm thinking of.
I could work on that.
Okay.
And leave things to Demi, so that people can have that from them. Yes, I could work on that. Right, Dominique?
Okay. Thank you.
Yeah.
All right, so we thank Brother Lowell for a very informative evening. Lots of food for thought, lots of things to digest. And if you notice, Brother Lowell, we were at capacity at all, right throughout the presentation almost. people might have jumped off and then somebody else came back on or something, but it was at capacity. So people were interested.
I was told that there were 200 and something people, 205 people on YouTube.
Oh,
lovely. It was better on YouTube.
Yes. We our 300 limit Zoom we don't have access to at the moment. So I had to use my 100 limit, but the YouTube was available, and we're thanking God for that. So thank you very much, Brother Lowell.
Anytime.
It was a lovely
and
evening.
As church always know that presentations on wills and estate and all those things. Just ask me, we arrange a convenient time, and for church, it's always done. So,
okay, so you all heard? Call on Brother Lowell anytime. Once it's for church, he will be there. Sister Chantal, we thank you for ably moderating this evening. You helped to ensure that it went smoothly. Brother Dominic, thank you for introducing the ardent Moravian, Brother Lowell Morgan. And Brother Del Warren, we're thanking you before you have done the closing prayer. And most of all, thank you, the participants who were here this evening, for staying with us, for asking questions, and for ensuring that it wasn't a wasted evening. Thank you very much. And we do this every year. We have a different topic. So if there's a topic to do with emancipation that you would love to have us do next year, please make the suggestions. We are open to suggestions. And it's way past some people's bedtime, so I won't keep us any longer. Brother Del Warren, please come with a closing prayer, and then we'll close with the anthem.
Yes, let us go to God in prayer. Oh God, our Heavenly Father, we just thank you, God Almighty, for this opportunity you have blessed us with, dear Lord, to be informed, oh God Almighty, on this platform. We accept and acknowledge, God, that you are the creator of the entire universe, of the earth, God, and you've called us to be good stewards. And so we thank you for the knowledge that has been imparted to us through your servant, Brother Lowell Morgan. And we know, God, that we have certainly learned, and we will also use this knowledge, oh God, as we go out into the world. Others. God Almighty, I pray for our dear brother Morgan as well. I pray for his strength. I pray for his guidance and comfort, even, oh God, as he continues to go through the grieving process as well, God. We thank you that you have blessed him and given him the strength to present today, dear Lord. We just thank you, God, for each individual here. In Jesus' name I pray. Amen.
Amen. Amen.
Good night, all.
Good night. Thank you.
Good night.
Blessings.
Good night.
Eternal Father, bless our land. Guide us with thy mighty
Not
hand.
guide, man, it's God.
Keep us free from evil powers. Be our light through countless hours. To our leaders, great defenders, grant true wisdom from above. Justice, fruit be ours forever. Jamaica, land we love. Jamaica, 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 land we love. Teach us true respect for all. Stir response to duty's call. Strengthen us the weak to change. Give us visions, let's
Thank you, sisters and brothers, for